Self-defense or deadly mistake? The Edmonton knife case that shocked a courtroom. Canadian legal precedents, self-defense or excessive force. In this episode of Canadian Legal Precedents, we explore a gripping case of self-defense, where one man's fear led to a fatal decision and a courtroom battle that followed. What happened? It was a quiet winter night in Edmonton, Alberta. Mr. K, a 37-year-old man, was home with his wife when he heard someone aggressively banging on the front door. The person outside was Mr. J, an intoxicated acquaintance who believed Mr. K had wronged him. Mr. J kicked the door repeatedly, shouted threats, and tried to force his way in. Mr. K warned him to leave, but when the door finally gave way, Mr. K, holding a kitchen knife, stabbed Mr. J once in the chest. Mr. J died on the spot. The police arrived shortly after. Mr. K was arrested and charged with manslaughter. Why is this case problematic? On the surface, this seems like a simple case of self-defense. But the question in court was, did Mr. K use reasonable force, or did he go too far? The law allows Canadians to protect themselves even with force, but only if the force is reasonable in the circumstances. The judge had to consider, was Mr. J armed? Could Mr. K have called the police instead? Was the stabbing necessary or a fatal overreaction? The arguments in court. Mr. K's lawyer argued that he acted in fear for his life and his wife's safety. The door was kicked in. The intruder was drunk, loud, and had a history of violence. Mr. K had no idea if Mr. J was carrying a weapon. A defense said he acted in the heat of the moment to protect his home. But the Crown prosecutor argued the threat was not immediate enough to justify lethal force. Mr. J had no weapon. A single punch, push, or even retreat might have stopped him. Was the knife necessary? The verdict and ruling. After careful deliberation, the judge ruled that Mr. K was not guilty of manslaughter. The court accepted that he genuinely feared for his safety and acted spontaneously, not with intent to kill. His stabbing was tragic, but not criminal. Mr. K was acquitted. What can we learn? This case highlights a key part of Canadian law, Section 34 of the Criminal Code. A person may use force to defend themselves or others, but the force must be reasonable in the circumstances. Courts will look at the threat, the options available, and whether the response was proportionate. Self-defense isn't a free pass to use violence. It must be justifiable. This was the story of RVK, a real case with a powerful legal lesson. Share this to help others understand their rights and responsibilities under Canadian law. Subscribe for more real legal stories simplified for everyone.